question is agreed by majority of the members present. I declare the motion passed.
交收系統修訂條例草案。
本會現在恢復2015年證券及
We now resume the second reading debate on the Securities and Futures Amendment Bill 2015. Mr. Kam-lam, Chairman of the Bills Committee on the above bill, will address the Council on the committee's report. Mr. Kam-lam. Mr. President, in the capacity of the Chairman of the Bills Committee of the Securities and Futures Amendment Bill 2015, I report to you I submit to you the report of the Bills Committee and report to you the salient points of our work. The bill seeks to enable the SFC, the Securities and Futures Commission, to provide supervisory assistance to regulators outside Hong Kong in certain circumstances upon request. Members noted that currently the SFC can only obtain information for its own supervisory purposes and may share information in its possession with regulators outside Hong Kong. The proposed supervisory assistance mechanism under the bill enables the SFC to provide narrow supervisory assistance to regulators outside Hong Kong in certain circumstances upon request by obtaining new information from licensed corporations, licensed LC. According to the administration, the proposed mechanism allows the SFC to engage regulators outside Hong Kong to negotiate more supervisory memoranda of understanding MOUs to enhance SFC's monitoring of the financial stability in Hong Kong. Members were concerned that the scope of information to be exchanged between the SFC and regulators outside Hong Kong for supervisory purposes may be unduly broad. The committee urged the SFC to prevent regulators outside Hong Kong from obtaining excessive information. The administration indicates that regulators outside Hong Kong can only request for supervisory assistance to obtain new information that must be in relation to an LC in Hong Kong that is also regulated by them. The requested information must be in relation to the regulated activities supervised by the SFC as well. The requesting regulator must confirm in writing that it has not been able to obtain the information by any other reasonable means and the information is not intended for enforcement purposes or use in legal proceedings. Before rendering assistance, the SFC will consider if it is in the public interest to do so. And that includes whether the requesting regulator is able and willing to provide reciprocal assistance within its jurisdiction in response to a comparable request for assistance from Hong Kong. Members also noted that an LC will be informed where SFC's request is on behalf of a regulator outside Hong Kong when a request is made. A member suggested that the SFC should also inform an LC of a relevant request for assistance, even if the requested information is already in the possession of the SFC at the time of the request to protect the interest of the LC. The administration indicated that under the existing provision of the Securities and Futures Ordinance, the SFC is not required to notify the relevant LC when disclosing information possessed by it. Members noted that some members of the securities sector are concerned that the SFC's collection of information may create undue burden to the industry. SFC stresses that the amount of new information to be collected from LCs, in addition to that are not already in the SFC's possession, should be limited. Firms that are not regulated outside Hong Kong will not fall under the ambit of the proposed supervisory assistance mechanism. Members inquired about the legal rights and protections affordable to LCs if, for legitimate reasons or practical difficulties, that they cannot provide information to the SFC. The administration responded that if an LC considers that it has a legitimate reason for not providing information to the SFC, it may set out its responses to the SFC to consider on a case-by-case basis. If the LC claims that the information attracts legal professional privilege or where the LC wishes to claim privilege against self-incrimination, the SFC will not pursue the information. Members noted the inadequacy of protections affordable to an LC if legal exemptions or privileges are not available under the laws of the jurisdiction of the requesting regulator. As advised by the administration, the legal provisions pertaining to legal privileges and exemptions in major jurisdictions are comparable to those in Hong Kong. The regulator outside Hong Kong, Mr. Leung Kwok-hung, I want to report to you that Mr. Chan Kin-po is not here and we don't have a quorum.
陳鑑林議員。
Mr. Chen Kam-lam. The regulator outside Hong Kong should undertake to preserve confidentiality of the information by taking all appropriate measures or receiving a demand legally enforceable. The committee has studied with the administration whether a review mechanism can be set up to allow LCs to seek a review on the decision of the SFC to provide information. The administration has advised that there is no such review procedure in the securities laws of other major comparable jurisdictions such as Australia, Singapore, and the UK. The administration considers that to have a review mechanism will run counter to the prevailing trend towards greater cross-border supervisory cooperation. Hong Kong will risk being excluded from global regulatory networks, enabling greater cross-border market access. Members asked the administration if there is any legal sanction against the requesting regulator outside Hong Kong which has breached the undertaking on confidentiality. The administration advised that in the context of securities market supervision, international regulators can only enter into non-legally binding MOU with each other. Each such MOU sets out the agreed scope of cooperation and each party's duties and obligations. If a regulator breaches this undertaking or any terms of an MOU, its international reputation will be seriously damaged. It may result in other regulators refusing to cooperate with it in the future. On how the SFC can ensure that a regulator outside Hong Kong will be able and willing to provide reciprocal assistance in response to a comparable request from Hong Kong, the administration advised that the proposed mechanism will only give the SFC a discretion to decide whether to provide supervisory assistance to an overseas regulator. The SFC will only enter into MOUs with jurisdictions which will provide reciprocal assistance. The committee and the administration has discussed on whether the process of entering into supervisory MOUs can be subject to negative vetting by the LegCo, for the LegCo to monitor the SFC's compliance with the relevant legislations and guidelines. The administration reiterated that arrangements for supervisory cooperation are entered into between securities regulators and not governments in the form of MOUs which are not legally binding. The SFC is a statutory body and must act within its powers at all times. Its decisions, including those related to the entering of supervisory MOUs, are subject to judicial reviews. Besides, the process review panel may look into cases of information exchange between the SFC and a regulator outside Hong Kong to ensure that the SFC will exercise its powers in a fair manner that is in accordance with the appropriate procedure. The committee and the administration will not move any CSAs to the bill. Mr. Deputy, I now speak on behalf of the DAB. The bill empowers the SFC to provide supervisory assistance with regulators outside Hong Kong on matters not related to enforcement. There is a need to improve supervision and to better comply with international requirements. The DAB in principle supports it. International cooperation is the trend and is also what the market needs, especially when Hong Kong is an international financial center. We are externally oriented. A lot of licensed corporations in Hong Kong are affiliated to international financial corporations. The activities of these corporations outside Hong Kong may have an impact on Hong Kong's LCs and the financial stability of Hong Kong. Empowering the SFC to provide assistance to overseas regulators will facilitate the SFC to put in place arrangements that are mutually beneficial And if necessary, the SFC can seek information from overseas regulators to perform its function. The amendment will enable the SFC to align itself with international standard. It would also urge licensed corporations in Hong Kong to access international markets that would otherwise be not accessible to them. Some members are concerned that the bill will give excessive power to the SFC and it will create undue burden to the industry. But there are some proposals to impose restrictions to overseas regulators. Say, for example, the request should not be frivolous. It should not be a fishing expedition, and the request should be in compliance with the functions of both regulators. And the overseas regulators will have to prove that they cannot obtain the information on their own, and the information sought is related to financial stability. There should be preservation of confidentiality. And if it is used for legal proceedings, they will have to make separate applications to the SFC. And in the exercise of power by the SFC, there are express provisions, and they is subject to restrictions, and they is also subject to judicial review and the balance of the process review panel. So the SFC will, in a fair manner, exercise its powers. And in relation to dispensing the issuance of printed licenses, and when a license is taken away or revoked, the corporation may be allowed to continue to operate, and also the adjustments of the levy and clear provisions of voting shares, and they all reflect the latest change in the market. It has also addressed certain enforcement anomalies, so the DAB will support it. This is the latest series of measures to improve existing measures, that is to improve cooperation, and this is conducive to ensure healthy development of the securities industry, which is developing rapidly, especially given the certainty in the global environment. There are a lot of challenges. In order to consolidate Hong Kong's status, we need to timely update our legislation, our ordinance, which is very important to development of our market. So apart from this bill, we hope that other ordinances related to regulation of securities and futures will be put in place so that we can continue to improve our market. I so speak to support the bill.
Mr. Christopher Chung. Mr. Deputy, after decades of efforts by the financial service sector, we have built Hong Kong as an international financial center. Hong Kong has China as its hinterland. Hong Kong plays a very important role in the international financial markets. We are completely open to the world. We have different financial institutions in Hong Kong. They are in different shapes and sizes, and there are all kinds of financial services provided. We need to be open to the world, and we also need to make sure that our regulatory system is in line with international practice. The linkage with different markets in the world are getting stronger and stronger. The regulatory bodies, therefore, need to work together to face up to new situations and to ensure financial stability. The financial sector and the SFC are working towards the same goal, and that is within a system which is open, fair, and just. The financial market can operate in an orderly manner. We therefore support the efforts of the SFC over the years, and we also agreed that the general direction of the amendments are acceptable. with regard to aligning our regulatory system with that of the advanced economies of the world, there is also the need to uphold privacy and confidentiality. The administration said that if overseas regulators seek information from the SFC and the SFC doesn't have that in Hong Kong, and that SFC will have to obtain such information from the LC, then the LC will be informed. The LC in question will be informed. To the extent that the information so obtained will be handed over to the overseas supervisory body. If the information is in possession of the SFC, then the SFC will not make any disclosure to the LC, which is the subject of that piece of information. So the right to know of the LC, therefore, is undermined. The administration has also pointed out that the cooperation or the assistance is not in respect of law enforcement, or it will not be used in legal proceedings. Since the information is not related to market misconduct, then the financial services sector is very concerned. At the hearing of the Bills Committee, they expressed a strong objection towards this. The trade has strong opinions towards the amendment bill, and I intended to move CSAs and require the administration to notify the LCs which are subject of the supervisory assistance request. I also wrote to the FSTB to further clarify my questions. Yet the Bureau just reiterated the protection or the security of confidentiality. The overseas regulatory bodies will comply with the provisions of the IOSCO to ensure security of or confidentiality of information. Having consulted the view of the legal advisor, the amendment is in respect of Section 186 of the SFO, so as to enable the SFC to provide assistance to overseas regulators. In fact, the legislation has been there since 2003. The power is already there. Therefore, we cannot move any amendment to deal with the legislation that has been enacted in the past. I and my constituency are very concerned about confidentiality. We can confirm that the SFC and the overseas regulatory bodies will be able to keep the information confidential, but our issue is the right to know. If the information does not relate to any offense, and the information is handed over by the SFC to the overseas regulators secretly, then the LC, that will be unfair to the LCs and also the institutions being investigated. The majority of the small and medium-sized brokers do not have overseas branches. They will not be affected by the new bill. Yet, as a representative of the constituency, I have to point out that there is a very high demand in respect of the standard, in respect of the right to know. The situation has changed over the decades. The SFC has still adhered to the old mindset and the old approach. Is it really appropriate? The SFC has the necessity to amend the relevant provisions. The supervised should be known, should be informed, and there should be a suitable balance with regard to the right to know and the effectiveness of regulation. links in the international financial markets are very close. There will be more and more requests for assistance put to the SFC by overseas regulators. When overseas regulators make a request to the SFC, then the SFC has to consider whether the request is in line with public interest and also supervisory and financial stability. And the SFC will only provide assistance if the information cannot be obtained through other means, through the reasonable means. Since we are not able to move any amendment in respect of providing information to overseas regulatory bodies, I suggest that the administration or the SFC will set up an independent committee in the event that overseas regulatory bodies seek information from and assistance from the SFC. Then the committee will consider whether the SFC will act or has acted according to the above-mentioned criteria. And it is also necessary to make sure that the mechanism will not be abused by overseas regulators. And only so will the financial sector feels comfortable about it. I'm not trying to make life easy. I'm not trying to make life difficult for the SFC or the overseas regulators. It's about the right to know. Now, the information is in respect of non-offense related information. It's not related, nor is it related to law enforcement. As far as information to be obtained, I think the LCs affected should be informed. Even if the administration is not able to set up an independent committee, I hope that the procedural review panel will step up its efforts in reviewing the cases in respect of provision of information to overseas regulatory authorities to make sure that the mechanism is fair and there will be no abuse. Let me reiterate, Mr. President, the SFC has made great contributions to the financial markets in Hong Kong with regard to the substantial adjustment caused by the A shares recently. There has been no panic selling in Hong Kong. We rely on market forces to adjust. And the SFC has not considered any administrative intervention. These are our strengths, and we have won the recognition of overseas media. The regulatory system has been effective, and I hope that the SFC will continue to exercise its duties to enable the markets to function in an orderly manner. We also need a fair and just system. Now, the bill has not addressed the right to know. I will listen to the reply of the Secretary before I decide on which way to vote.
Mr. Kenneth Leung. Mr. Lau Kwok-hung, I report to you that we don't have a quorum. Mr. Chen Kin-po is not here. If it's a point of order, would you please point out which paragraph? No, I read it. I need to point out to the chair, to the president, that there is no quorum. Mr. Kenneth Leung. Mr. Deputy, I am a member of the Bills Committee. The main amendments of this bill is to allow the SFC to provide supervisory assistance to overseas regulators, that is, regulators outside Hong Kong, by providing information. The Bills Committee held 3 meetings and 1 public hearing. Deputations, the 4 of them, which attended the hearing, expressed concern towards the bill. I remember during the first meeting, lots of members raised a lot of questions in relation to the object of the bill and its operation. They are mainly about 3 points. First, information, whether the information is unduly broad. 2, deputations who have attended the public hearing said that they will have to spend a lot of resources and time to provide the information. And the third area of concern is that whether these overseas regulators, after obtaining the information, will put the same to what use? For investigation or law enforcement, perhaps? The fourth area is confidentiality. After the first meeting, I have actually done some work. I personally went to Mr. Ashley Elder, of the Chief Executive of the SFC, to find out more about background information of the bill. And I've also spoken to a number of related bodies, say for example the Alternative Investment Management Association Limited. This bill is to align Hong Kong's practice with that of international jurisdictions. But how come there are so many problems identified even at the first meeting? I hope the government will listen to my views. When you introduce a bill, I hope that at the first meeting you will clearly state the background of the bill, why it's done this way, and whether it is in line with international practice. In the first meeting, I was unable to obtain the information. I had to have a separate meeting with the SFC to get the information. Well, after attending meetings and meeting with the bodies, what have I learned in relation to scope of information? Not all overseas regulators can obtain information of LCs in Hong Kong, because the LC in Hong Kong will have to be at the same time regulated by the overseas regulator before the overseas regulator can obtain information of the LC in Hong Kong. Or a related corporation of the LC is regulated by the overseas regulator. Then the overseas regulator can get the information, and the information obtained should be targeted instead of a fishing expedition. When I made inquiries with the SFC, they have given me some information about confidentiality. Say, for example, legal privilege documents, personal data information, commercially sensitive information will not be given to overseas regulators for no reason. How come I have to find the information myself? Why can't I get the information in the Bills Committee? I ask the government to give it some thoughts. Well, in the coming 7 or 8 months, there will be a lot of bills from the SFTB. I hope the government will be better prepared by giving us sufficient information so that legislators will have complete information for us to scrutinize and consider the bill. In relation to resources and time to provide the information, in the past, most of these supervisory information is in the possession of the SFC. So the exchange of information between SFC and overseas regulators will not result in the use of a lot of resources and time. Another thing is, through the exchange of information mechanism, the number of times the SFC has to obtain information from overseas regulators is actually higher than the other way around. And that's gleaned from the statistics. After hearing from the SFC, deputations think that the amendment in the bill is in line with international practice and standard. A concern shared by members and deputations is that once information is exchanged, will the supervisory information be used in an investigation or in a legal proceedings? In law, it's not allowed because under the existing SFC provision, there is another clause allowing the SFC to assist overseas regulators in law enforcement. And this is a specific exchange of information provision. The information exchanged cannot be used for purpose other than the one stated. You may ask, how come that all of a sudden in 2015 there is a legislative amendment to give more power to the SFC? The reason is not that of what most people think, like Mr. Christopher Chung, that the Chinese Commission, that is a CSRC, would need the information for enforcement. No, the request did not come from the CSRC. Several years ago, the regulator of the EU said to the SFC that the passport regime will see a major change shortly. And if LCs in Hong Kong, say for example you're an investment advisor or you're an asset manager, if you're a licensed person, if you want to sell in the European Union some instruments, the first and foremost condition is that the Hong Kong regulator will have to be able to exchange information with the EU regulator. This gives access of Hong Kong LCs to European markets to sell their products or securities, and that is very important. And that is something that I have learned after speaking to some bodies, and that is the original intent and the object of the bill, and it's a waste of legislators' time. Of course, it's part of our work, but doing it this way means it's opaque, because a lot of this will have to be made clear in the Bills Committee meeting. And is there the room for improvement of this bill? Yes, there should be strict compliance with the confidentiality requirement. I know that in the existing legislation, if there is exchange of information, there is no requirement that the regulated party will have to be notified, but a responsible and transparent regulator should take an initiative to compile enforcement guideline. Of course, it doesn't include exchange of information related to law enforcement. I'm only talking about exchange of information under this supervisory assistance mechanism. SFC should notify the LCs that there is an exchange of information conducted with a certain regulator. And this will give some peace of mind to LCs in Hong Kong. I hope the SFC will put in place guidelines and comply with them. I so speak to support the second reading.
Mr. Chung-kai, thank you, Mr. President. At the Bills Committee, having heard from the deputations, I commented that it would be very difficult for the bill to be passed. But of course, afterwards, through the lobbying effort of Dr. Kenneth Leung and other members, the situation has changed, and I'm not going to oppose the bill today. But I think the focus is to exercise prudence in overseeing the regulator. The framework is about the regulator, but we want to know the powers given to the regulatory body. We are going to give more powers to the SFC under this bill, such that for non-enforcement purposes, supervisory information can be shared with other regulators. As a regulator, its conduct is very important. It has a huge influence on the market. If there is misconduct on the part of the regulator, then who is to regulate the regulator? Our regulatory regime in Hong Kong, of course, is much better than before the SFC was established. We have a process review committee or process review panel, etc. I think, Secretary, you know this more than I do. In other jurisdictions, we understand that the regulatory body will also be subject to other kinds of oversight. Now, for example, Secretary, you today received a lot of media inquiries. Mr. Charles Zhou Xiaochuan said that the Shenzhen Hong Kong Connect is expected to commence by the end of this year, and then the Hong Kong stock market surged, and the article was actually published in May. Well, of course, the market somewhat cooled down in the afternoon, but one has to wonder whether there is any manipulation in the market. How could an old article be dug out to boost the market? Well, of course, I understand that this is the mainland market. Well, we have to be careful anyway in giving the SFC more powers. We need to be careful whether someone is manipulating the mainland market, which would affect Hong Kong market. We are interrelated because the mainland market changes would affect Hong Kong's market. Of course, we may not have the ability to affect the mainland market, but anyway, I'm concerned because ever since the Lehman Brothers saga in 2008 across the world, and in fact, in the past 8 to 9 years, there have been a few stock market crashes. There was a major one in 2008, the financial tsunami, and other crises. There is a demand, of course, to oversee the market to prevent market manipulation. But the focus is this. When we share supervisory information with overseas regulators, is it doing good or harm to the local market? When we give out information to others, and I also asked this question a number of times at the Bills Committee, because the mainland market I mean, the mainland system is this: a person can be a government official one day and then and work in the private sector another day, and goes back to be a government official the following day. And Dr. Kenneth Leung approached Mr. Ashley Elder, the CEO of SFC, for clarification. And he also explained to me just now, if the bill is passed, according to him, it's more likely that the SFC will obtain information from overseas regulators than the other way round. Mr. Christopher Chung is concerned about some issues. The small brokerage firms in Hong Kong should not be affected, and when they conduct business overseas, and when information is sought in relation to these SMEs or the firms, information should not be given. Well, perhaps you can clarify in a moment. But for overseas corporations to tap our market, the SFC may have to obtain supervisory information from other regulators. Now, I considered the proposal. I think it's very difficult not to give the SFC the powers. Well, some deputations originally objected to the bill, and for some reason, eventually, they were sort of silenced. And the SFC will be empowered to share supervisory information with its counterparts overseas in terms of the right to know, confidentiality. Well, I'm not talking about enforcement. Of course, you will not notify the LC of the enforcement action. But I'm talking about obtaining supervisory information. The data subject should be informed when information is sought by regulators outside Hong Kong. And Dr. Kenneth Leung just now mentioned the possibility of drawing up internal guidelines. I hope that after the bill is passed, the process review panel could oversee this to make sure that there is some internal governance. Because I must emphasize that we're talking about regulating the regulator. How we can have checks and balances. This is important. I think Mr. Albert Ho in a moment will talk about this as well, because sometimes the SFC may step maybe out of line. So for institutions with that poses a systemic risk, their international activities may affect the market, like I said. And as an important international financial center, we must be careful. And after 2008, because of the subprime crisis in the U.S. and the Lehman Brothers saga in 2008, the market crashed and asset prices fall. Members of the public might have been misled into buying these products. The financial crisis happened in January 2008, but in fact, in the past 7 or 8 years, there have been much market fluctuations, and the Eurozone crisis also caused much fluctuation in the financial market. And we now have the Shanghai-Hong Kong Connect, and in May, Mr. Zhou Xiaochuan said that it will, the Shenzhen-Hong Kong Connect will commence it by the end of this year, and you commented that we're still waiting for the mainland's approval. So what's the point of writing this article? In fact, the article wasn't even published today. It was published in May. I don't know why this 5-page article was uploaded onto the website online. I don't know whether it's really a man-made manipulation causing the fluctuation. Well, this would lead to some regulatory issues. So what we want is that for those with non-binding effect, well, because we're talking about an honest system with confidentiality agreements. And I also asked at the Bills Committee, what happens if somebody leaked information? Because some information may be of a state secret, and one may not be able to get this information. Well, when the mainland regulator asks for this information, if we have the information, we can give them. But what happens if it's the other way around, that it's a state secret and cannot be given? So, Secretary, I hope that you would require the SFC to enhance its internal checks and balances. At least something should be done. I don't know whether the process review panel can draw up guidelines to ensure that no onward disclosure or improper use of information provided by the SFC would be carried out by overseas regulators. And the bill also requires that the information sought must be related to the regulated activities of the SFC, and it must be in the public interest or investors' interest. Well, and I also mentioned just now, on the other hand, that the scope of information to be exchanged may be unduly broad. Although the Bureau or the government already explained that the information of the subject should be somebody regulated by either the regulator in Hong Kong, overseas regulator, which may affect the financial stability, it is still very broad. What is meant by constituting a risk or affecting the financial ability of the relevant jurisdiction of the authority or the regulator? There should be some objective criteria in considering the scope of information to be shared. For example, what is meant by or how to enhance the transparency in terms of systemic importance to a financial structure, and also on giving information to SFC without complying with the regulations overseas. Well, so in short, Secretary, you have the responsibility of urging the SFC to comply with this piece of legislation, and there should be all the checks. There should be checks and balances. Will there be some kind of report, or at least internal report, to the Board of Directors or to the Process Review Panel? I think internal checks and balances must be set up. Otherwise, more information will be shared without legal basis, and the protection for LCs will be undermined. So the SFC should be the gatekeeper, and internal guidelines should be drawn up, or internal monitoring system should be drawn up within the SFC, so that when information is provided to overseas regulators, although it's reasonable to notify the LC, but even if the LC is not notified, there should be consideration of whether it constitutes a risk or affecting the financial stability of the jurisdiction of the regulator. So, Secretary, I hope that you would, when you respond, you could also address my concern. I'm not going to oppose the bill.
Mr. Abeho, Mr. President, as said by my colleagues, in respect of the overriding principles and in respect of international financial order, we should support the bill. Yet, in dealing with the bill, which seeks to increase the powers of a regulator or a law enforcer, then the legislators will have to look into this bill very carefully. Will this power be used well, or when the authority is empowered, is there a suitable check and balance? Now, you have just heard, Mr. Chan, the Secretary, that, or rather, Mr. President, you've heard the reply by the Secretary. There are two mechanisms for us to supervise these regulators. One is the process review panel. The other is JR. I'd like to speak on these 2 points. Your process review is just navel gazing. The panel is not set up to deal with cases or complaints. They just look at the procedures. And under the SFO, you can see that there is a confidentiality provision which is used to ward off the complainants. If you make a complaint, your complaint has fallen on deaf ears. You are not told whether there is any follow-up work done. As for JR, I've paid attention to many JR cases. There aren't too many against the SFC. The SFC wins always among the small number of cases against the SFC. It shows that this is not an effective mechanism. For the super big consortia, in particular those have state government, those who have a government background, the SFC will not deal with it fairly. Let me give you an example. I'll give you an example later. And if the organization has power to fight the SFC, then they will not try to offend the SFC. As for small investors, I will give you an example. Even if the complaint is well justified, they even don't have the ability to go down the JR route because they don't have the money to fight the SFC, and their means are higher than legal aid threshold. Therefore, they really can't fight the SFC through JR. The JR mechanism is not effective. When they make a complaint, when it goes to the ombudsman just turn it down unless there is any administrative failure. Say, for example, you do not reply to their complaint letters or their telephone calls. As for unfair decision by the SFC, the ombudsman will not deal with that. And our complaint section also cannot handle that. So is there any check and balance at all? Many decisions by the SFC are really controversial. Let's take the Lehman Brothers incident as an example. There were many complaints that the banks engage in malpractice in marketing. How many disciplinary actions have been taken against the banks? Quite a few and far between. Let us accept that the Lehman Brothers incident was a disaster and the situation was rather unstable, and therefore in order to compensate some minor or small investors, therefore they exercise the power to force the banks to settle their cases with the small investors, and therefore the banks would not be disciplined. Okay, let me set aside the Lehman Brothers incident. Well, I will refer to other cases because my clients may be President, my clients may be involved, and Mr. President, you will know the interests. Since I'm their lawyer, therefore I have issued letters on their behalf. First, CITIC, a super state-owned enterprise, it lost more than tens of billions of dollars. Knowingly, their directors, the chairman of the board, issued false information. That was very clear. The community was in an uproar. How could that be? It was really impossible for them to not knowing that the information was wrong. The administration investigates into the case, and then on the last day of the 6th year, there was an action, and that is the Market Misconduct Tribunal then took action. There was no progress in terms of pursuing the criminal route. You may claim that you would like to seize documents, but they had a big legal team. They tried to drag your feet. They tried to appeal. I don't know what offenses you want to prosecute them, but releasing false information was a crime. They lost more than $10 billion, and in August and then in September they released false information. I'm not asking you to prosecute them for fraud, but you don't even prosecute them for releasing false information. What the SFC is doing, you use the MMT to prosecute them. Therefore, they have released false information. Why this simple criminal prosecution is not mounted? Because it is a state-owned enterprise. Second example is in respect of a development by Chung-kai. Now, it was a hotel, and then it was sold separate. The units were sold separately. The SFC said that it was a collective investment scheme. I refer to the Apex Horizon. Now, if they didn't recognize that, then you should sue them. Instead, you settle the case with them. You ask them to unwind the scheme and then settle it with the investors. Chung-kai, therefore, talked to those buyers. They said that SFC didn't allow us to sell. And then I didn't argue with SFC. I paid you the deposit, pay you back the deposits, and then I give you a 1% interest. Now, it is an investment. Now, according to the contract, if you didn't close the deal, then Chung-kai will have to pay 100% back, pay 100% on top of the deposit. Now, if you do not close the deal, you have to pay Chung-kai the deposit with and also 100% on top of that. But Chung-kai didn't do so, and therefore, people complained to the SFC, and then SFC said that the matter had been settled, but the contract is there, and the buyers refused to take money from Chung-kai. I wrote to the SFC. Now, you should decide that you should decide on prosecution because it's a collective investment scheme. And at the end of the year, the SFC wrote back to me, and then the SFC said that it would reply on at the beginning of this year whether it would prosecute or not. Up till now, no reply has been given. Now you say JR is okay, but how can small investors go to apply for JR against Chung-kai? Is the panel effective? I have not heard anything done by the process review panel. What has been done by you and what has been done by the FS? They went to different departments to complain, and the answer is sorry, we can't do anything about it. Let me give you a third example. Mr. Christopher Chung, listen to it carefully. A small runner, broker, he received money from investors. This is the Good Cape Securities Limited. It received about $10 or $12 million in Chun-yan. They got the money from the investors. They claimed that they bought shares on their behalf, but actually the broker embezzled money and ran away. People were concerned, the investors were concerned. They asked about it from the SFC. SFC said that according to their record, there was no complaint, there was no bad record. And then finally, everybody knew it. The money was taken away by the board of directors. The money gone. There were no securities held by that company. Shouldn't the SFC take action? Up till now, Mr. Chen, only CCB, the Commercial Crime Bureau, studied the paper. Maybe assets had been frozen. They refused to tell us anything. If a case can be established, the directors have all gone, and the victims have the reasons to believe that if action had been taken by the SFC when a complaint was made, then the SFC could have frozen the personal assets of the board of directors. When the CCB said it is a case to be followed, it was a case to be followed, all the board of directors have sold all their property. And up till now, there is no receivership. The SFC didn't. The SFC hasn't taken any action to receive that company. What is the SFC doing? The SFC has no interest in looking after the small investors. The SFC just looks after the interests of big consortia. Well, it will not affect my inclination to vote. I'm planning to give you a notice. A colleague will move a motion to condemn the SFC and express regret against you and the FC for failing your duties in supervising the financial institutions. The SFC just ignore the small investors. They don't treat small investors as human beings. This is my response to your claim that the government, the response given by the administration to the Bills Committee. The SFC is an effective channel, and the effective channel is the process review panel and also JR. It's all nonsense, I tell you.
其他議員要發言。
Does any other member wish to speak? Mr. President, we don't have a quorum.
仲有冇議員要發言？
Does any member wish to speak? Sorry, speaker's not coming through.
主席，呢個即係我正。
Chairman, where is Mr. Albert Ho? He's here. Well, Mr. Albert Ho has made an eloquent speech. However, not many people were here to listen to him. He was speaking for small investors and shareholders. Well, people are leaving. There is nothing I can do, but I have to speak for small investors and shareholders. DAB has been saying that there is nothing trivial about livelihood. Mr. President, have you purchased any of these products that will eventually kill you? Well, I was a member of the Lehman Brothers Select Committee. A lot of people accused me of not doing anything. Well, what do you think that the SFC has done? Because for a single area, there are two regulators. You say that they regulate products, and they said that they only regulate the sales brochures and the promotional materials. Well, actually, it should be the SFC who take action, not the Hong Kong MA. Because the Hong Kong MA will only check documents under the banking ordinance. I've asked Mr. Joseph Yan, based on what that he took action. He said he would just look at the records of banks to see if that capital accounts show that were sound. And it's nothing to do with how they purchase the products or how they sell the products. We're talking about transactions of millions of dollars, and the transaction actually took place at MTR stations, and there was not even an audio recording. I don't know whether it's done now. We have to ask Dr. K.K. Chan, the secretary. I don't know what improvement measures have been taken by the SFC. I can only do so much by myself. Mr. Albert Ho was venting, moaning for small investors. And I was also involved in the CITIC Pacific company. And there are two people, one named Fan, one named Wing. Well, because the CITIC Pacific engaged in speculation of accumulators and suffered a loss of tens of billions of dollars. These two people were asked, well, you can't, it's a bottomless pit how much you can lose. And they said that we have asked professionals. And they were asked, what did you ask? They said, well, accountants and barristers. And it was in the old Ledco building. I asked, who are these people that you've asked? How come they have given you amazing advice by teaching them to break the law? And so far, we don't know. We still don't know. Do you know, Mr. Albert Ho, which barrister and which accountants said that it was okay? It's blatantly obvious. They are still alive and kicking. So, Professor Chan, what do you say about that? What do you say about that? Just now you were saying with confidence that there can be process review panel, otherwise there can be judicial review. So there are some very sound checks and balances and safeguards. So I want to ask you, if what I said is true, then to whom can one seek redress? Well, if you talk about a process review panel, well, the SFC can ignore you, and if it's judicial review, it's doomed. Why? Because you don't have any money. And Albert Ho, you can't apply for a judicial review against the CITIC Pacific. You can only take that to court because judicial review is in relation to public power. So if the SFC doesn't do it, I want to ask you, Professor Chan, Well, since you do not supervise them, can I take out judicial review against you or Zhang Zhang? The two of you are above everyone else other than the chief executive. And there was also this Financial Stability Council Commission. So if you two do not do anything, then I take out a judicial review against you or against the SFC. Professor Chan, can you give me the figures, how much it costs to have a judicial review? And victims of Lehman Brothers or victims of major corporations, those being cheated by structured products. Well, it's 3 or 4 years ago, the sales brochure. The SFC doesn't even care whether the information thereon was genuine or not, because there was no way for them to verify. I don't know whether you know, Mr. President. Well, there is a bunch of products, say 10. And as long as on the day when it was sold it's AAA, it's fine. It doesn't matter that the next day is not, because they can say, well, we don't know that you have bought something like that. The SFC can't help you because you have bought products that are sold by the banks. So today is a AAA, and then after you bought it, it's only AA or it's worthless. Then no one will care about you or help you. But we're talking about promotional material. And there is also this booklet, the sales prospectus. It's as thick as a phone book, and no one can understand it. The ordinary people will only refer to the sales leaflets, of course, right, Mr. Christopher Chung? Mr. Christopher Chung? Because the prospectus is very thick and is in English. So, Professor Chan, has there been any improvement? If the SFC back then, when all eyes were on them, gave the CITIC Pacific a way out, well, is something like on Halloween what Chun-yan did, and if it were someone else, an arrest would have been made. Well, I confronted a police officer during a march, and immediately pepper spray was used on me. So, someone enjoys privilege. Isn't it the case that the SFC should catch the big ones and let these small potatoes go? It's not fair. I don't want to speak because I'm not a party to the bills, to the scrutiny of the bill, but Mr. Albert Ho was moaning and complaining on behalf of small shareholders and investors who have been cheated. I want to ask you, Professor Chan, perhaps you answer me. Well, what can you do out of the two options? Well, what is the success rate? Well, you say, well, there is the process review panel. And of course, is the same group of people looking at the same thing. And if it's judicial review, what is the success rate? And how many people will have the money to take out a judicial review, get a judgment, and then follow it up with the private organization? Will they take such a long way round to do it? It's almost 8. You, of course, will have enough vote. You can just leave some pigs here to do it. If Kwok-hung very much likes to do it a lot, thumbs up, thumbs down, and that's how it works here. there isn't something that is even more complicated. So if thumbs up, then it will be endorsed. And for your health and longevity, I will stop here. Professor Chan, you are very diligent secretary, much better than Mr. Chen Kin-po. Chen Kin-po is not here, as I've reported repeatedly, but you've sat here all along. And there will be an insurance commission. So maybe tomorrow morning you will give us some answers. Teach members of the public about how they can get justice. I report that is now 8 o'clock. Thank you. Council will adjourn to be resumed at 9 o'clock tomorrow morning.